hearing. Alright. So, you are,
We have, so
we have to open up,
just looking, just to mark the application that was submitted. So we have,
I have that.
I have an application here, which was filed with the Village of Washingtonville, application to Board of Appeals by 1 Nicole Street LLC. Ultimately, this was filed with the Village of Washingtonville, marketed as Exhibit A for the purpose of the record.
Okay.
Did the board receive the application on this property?
It was sent by email.
Okay. I can follow up, provide everything just like the last applicant. I can also summarize to the best that I can.
Okay.
I don't have any presentations for the screen, but I can describe it and hopefully, you know, if you have any questions, board members on the Zoom call, feel free to chime in. I'll stop and I'll address them right away. I do have the proof of publication for the file, and like we discussed a minute ago, I have the affidavits of mailing that I provided, and I will provide the certified green slips that were mailed out to all the adjoining property owners within 500 feet of the subject property. So I do have that, all the notice requirements were complied with. To the Honorable Chairperson and to the board members, Mr. Kleister, thank you for having us tonight. So just to very quickly give a brief history, in going back into April of 2020, the building inspector issued a violation against 1 Nickel Street LLC for operating a 2-bedroom in a 1-bedroom R100 zone, 2-family in a 1-family R100 zone. In June, we submitted an application to the zoning board asking for, basically for special exception use, but that application really should have gone to the planning board, which we did. We applied to the planning board in August for the special exception use to operate the 2-bedroom, the 2-family in the 1-family R100 zone. We appeared before the planning board in November, where we were referred by Mr. Terry at the planning board meeting to the zoning board to get 5 area variances. Now, if I may very quickly go through the code just to address the area variances and the interpretation that's being asked for here. If you look in the code section 315-11F, 2-family is, I actually believe it's, I don't know the new code numbers. I have the old code. It has the 175 numbers. So I'm going to read the section that any permitted use in an RA district is permitted as a special exception use in the R100 district. So if you go to the code for the RA district, a 2-family dwelling is allowed as a special exception use in the RA district with certain requirements. There's a frontage requirement of 220 feet, and then it also doubles the side yard requirements. And so for the zoning board members, I did in my chart laid out the 5 area variances that are being requested. I laid out the distances in on the property, and then what the requirements would be in the RA and the R100 section. And so as you can see, the minimum lot area that is provided by the property is 17,960 square feet. In the RA district, it would be a 40,000 square foot requirement. In the R100 district, it would be a 20,000 square foot requirement. The front yard setback, we have 40.7 feet. In RA, it's 45 feet that's required. In R100, it would be 40. Those are, and then looking at the 1 yard side setback, we have 9.3 feet. We have 20, and as well as 23.8 feet. We'd be required in the RA district to have 40 feet. In the R100 district to have 30 feet. Both side yards, ours is at 32.2. In RA, we would need to have 100 foot setback. And then in R100, we would need 80 foot. And then the frontage requirement as per 315-11F, the frontage requirement, there's no requirement in R100 district. The RA district has a 25-foot requirement, we provide 160 feet. So these are all area variances. The issue about the interpretation, I refer back to the language of, section, what it would be, it was previously 175-11E, but it's the RA district, I apologize, I don't know the new code number, I think it might be 315-11, but I'm not sure. So, a two-family dwelling provided that the lot upon which said dwelling is erected has a frontage of 225 feet. In such case, the side yard requirement set forth in section 175-10 shall be 2 times the minimum requirements. And so, the question of what does the 2 times minimum requirements apply to is the basis for the interpretation. Does the 2 times requirements apply to the RA district or to the R100 district? Our opinion is that it applies to the R100 district. However, honestly, it shouldn't make a difference because we're asking for 5 area variances here. And when you look at all the different factors that should be weighed in adjudicating the area variance, there's no real undesirable change to the neighborhood of the community. I've outlined that in the application, in that if you look at this property, it's located on the zoning map in the bottom southwest, bottom left corner of the R100 district. And so the location of this property is kind of in what I would call an armpit of the R100 district. It's touching the non-nuisance industry district, it's touching the mobile home courts industry, the mobile home courts district, and it's touching the office residence district. And it's also very close to the office building research institute or laboratory district. And so, in terms of the undesirable change to the neighborhood or community, it needs to be recognized that this property is in a very specific location in the community where it does touch on all of those different districts. In terms of whether or not the benefit can be achieved by some other method, it really cannot, my client cannot move his property, move his dwelling physically to adjust the setbacks. And then similarly, if, you can stop if you want.
We're going kind of quickly.
I'm trying to.
No, I get that. Can I just ask a couple questions?
You absolutely can.
Is this your primary residence? Is this
No.
for a family?
This is
Is this like a mother-daughter?
this is a 2-family house.
Well, when you purchased it, it was a 1-family house.
When I purchased it, it was a 2-family.
It's actually listed on the tax records for the village as being a 2-family dwelling. It was listed as that when you purchased it. It's still listed as that, and I outlined that in the application in terms of whether it was
Is
self-created.
John here?
I'm hiding over there.
Oh, there you are. I'm sorry, I didn't think that it was listed as a 2-family?
Stephanie?
Yeah, so I'm here to answer any questions in
Okay.
regards to interpretation. So, Zoom board members, please let me know if you can't hear me. My name is Stephanie Chudek. I'm the village attorney for the
Right.
village of Washingtonville. I'm also the planning board attorney, but I'm here on behalf of the village to represent the building inspector.
Okay.
So, while yes, the county tax, like when you look up on Orange County, it is shown as a 2-family house. For purposes of the village records, it is a single-family home.
Right.
Now, the applicant may have purchased this as a 2-family home, but that is because there was a special agreement between the village and the previous owner, which there's an affidavit here, I think it was provided to the board members,
Right.
that specifically allowed them to use the property as a 2-family, but once their ownership was extinguished, they had no right to this.
Well,
They had no
Right.
further owners had the right to use it as a
Right.
2-family home.
It was my understanding that it was actually not a 2-family, but a mother-daughter.
I believe that's correct,
And
yes.
what happens with a mother-daughter, there are special, requests that are granted when it's a family member. And what happens is every year, the building inspector goes to the house. You have to prove that it is a family member. You sign a document stating it's your mother, your father, your whatever. But I don't believe it was ever a two-family. I know it was they had a,
If I may, just very
go
quickly.
ahead.
My client did make entries to the town asking for information about this before purchasing the property.
Correct, and
And
he was told specifically that this was not to be allowed as a two-family home.
I do have documentary evidence of that, because we don't have that.
I mean, if
My
you-
client,
Would
I-
like
yeah.
to see that documentation if
So-
possible.
and I've never been provided any of that
So
documentation.
there's no, I mean, there's no documentation. My understanding is that the building inspector's assistant met with I'm not sure if it was you or a representative, and we can have her here and testify if you'd like. We can certainly arrange for that to occur. But prior to purchasing the home, he did come and inspect building department records and was explained that this was not a two-family home to be used for,
I'll defer to my applicant, I'll defer to the applicant.
If I may
Let me
correct-
ask a simple question.
Mhm.
When you purchased it, did you pull title from the village?
Yes.
It says two-family home.
So,
You
Where's
got municipals from the village?
We got tax records, municipal, go ahead.
we requested municipals,
Mm-hmm.
but the clerk said that we cannot get municipals unless we have an affidavit of smoke detector signed from the seller. And it was a foreclosure sale, so there was no seller, so the referee
Is
didn't want.
the house mortgaged, or did you pay cash? Just, because you don't have to pull municipals if you're purchasing with cash.
I actually did take a mortgage,
Okay.
but
Because you
I
can't close
personally-
without municipals.
I personally
well,
worked.
sometimes you-
Well,
it depends on,
if
it
I may-
depends on the loaner. I
Okay,
understand
1% of the
general.
time you
I-
can.
If I may, very quickly, if I may, just to make this point, there might be a disputed fact, whether or not my client was informed. We are very confident, we're under the, it was not conveyed to my client
Right.
that this was a two-family home, a one-family home, and that it couldn't be used as a two-family home. On the tax records say it's a
That's
two-family
because
home.
that's because at the time that
I'm just making the point.
No,
I
I
understand what, you know.
I'm explaining our side. At the time that it was assessed, it's assessed as a two-family because it was being used as such, but that permission was specific to that owner. It was conveyed to, and like I said, I can bring in, what's your assistant, Susan?
Yeah.
Here this week, she'll be back on. Okay, Susan can come to the next, Zoning Board of Appeals meeting, and we can have her, testify, or if you, in the alternative, if you want, she can prepare an affidavit. But she did sit down with a member of that, at that time, prospective buyer, which is essentially why the village is.
I think, so if
It's
we're
kind of
going.
like a power of attorney.
I understand.
It
So if we're
dies,
going-
it becomes void upon death.
Fine,
So when
but-
that person sold, it was no
But
longer.
if we're talking about a self-created hardship here. My client did the due diligence. He was under the impression that it was a two-family home. He did the due diligence. Not only that, the self-created hardship is not a determining factor when deciding on an area variance, right? So you need to weigh all the
Right,
factors.
what is the
and-
hardship?
Excuse me?
Well, what is the hardship?
To my client, if my client has to operate as a one-bedroom, he has to remove
One family.
a family dwelling. He has to actually reconstruct the home so that it would be a one-family dwelling. It has an
No, all he has
apartment
to
in
do
it.
is take out the stove.
Hey, there's a lot more work involved, and he's losing the revenue of having a second
Well,
renter
did
in
you
the
buy it
family.
as an investment, or did you bought it?
Investment.
What is the intention? That's what I would like to know. What is the intention and what is the R100 zone is single family?
Right,
The R100 zone allows, by special exception use, any permitted use in the RA zone, and in the RA zone, a two-family dwelling is a permitted use. So a two-family dwelling is a permitted use in the R100 zone. It might be permitted by special exception, but it is permitted.
but it has to be, there has to be
That's a
proven
decision for the
without a
planning board.
reasonable doubt that there's a hardship.
That's a decision for the planning board. At this stage, it's just the balancing of the hardship to my applicant against the detriment, health, and safety of the village, which there will be none done here if the five
Well,
area
there's
variances are
variances
granted to my
that
client.
can't be met right now, so.
So let me just clarify. So according to the code, okay, the special exception use comes from the planning board, correct?
Correct.
Okay. So you went to the planning board, you made application to them to allow you to use it as a two-family.
Yes,
They referred you to the zoning board.
correct.
Without granting a special exception use,
Upon the approval of the variance, we are going to go back to the planning board for that special exception use.
so basically, the zoning board's question is one, what setbacks apply pursuant to what district, correct? You're saying that we should use the R100 side yards and setbacks, correct? And the Village of Washingtonville's position is that because you're using the special exception to the RA district, that you should apply those setbacks. So that's one interpretation that the zoning board has to determine.
Yes,
Which is, if the board, is the board clear on that? Ultimately,
Right.
in the R100 zone, if you build a house, in the village code, there's setbacks, okay? 10 feet side yard, I'm using these hypothetically. So then in the RA district, there's other setbacks, they're different, they're bigger, okay? The use in the RA zone district, which is for a two-family, the village's code says in a R100, you can have a special exception use that's mentioned in the RA district, okay? The applicant is saying because you're going underneath the RA district to get into R100, we should use, or the village should use, the R100 setbacks. The village's position is because you're going under the RA district to get the two-family into the R100, you should copy the setbacks from RA district.
correct. Mr. Kleiser said that perfectly.
That's-
I mean, you
That's
said that,
that's the one interpretation that this board has to determine who's right.
correct, correct.
Because then the next question is, they're telling us how big the variances are they need. Some will be doubled by the RA district application as compared to the R100.
Yeah, I mean, you essentially got it right. The things that will be doubled would be doubled in both the RA and R100, but the doubling increases it more if you use the RA district. For the board members, just so I can very simply state my position on the interpretation, why would you apply the RA district to the R100 district? I understand that you're doubling the requirements, but it just doesn't make sense to take requirements from another district and apply it to the R100 district. Why not double the R100 requirements in that district? That's what the code says, that's what we feel the code says.
Because RA is two-family, R100's not.
I understand the position of the village, I'm just very, very simply stating my position to the board members. Now, if I may, moving on from the interpretation, I feel confident that however the decision is made on the interpretation, when the balancing factor is done on each of the area variances, it still has to come out in my client's favor. There's no detriment to the village if these area variances are granted. There really is not. The benefit to my client is substantial. It's a straightforward, it's a straightforward area variance analysis, and there, I provided our justification, and so I'm open to entertaining any questions from the board. But I think it's clear that the area variance is.
So it has been operating as a two-family unit. Now, was the kitchen added after you purchased it?
No, it was all there before.
Okay, so it's been operating, it was a mother-daughter before.
I cannot answer that.
So is the board, did you receive the documents from the Village of Washingtonville, one of which I think we referenced before, is an affidavit with the prior owner? I think it details out what they were allowed to do with the property under the two-family. That's detailed in the affidavit. Council referenced that.
Do you have that? You have that?
Mhm.
Why wasn't I providing a copy of this?
No.
I didn't even know it existed.
I was just trying, but your client knows it existed.
He didn't know it existed.
He did because he was showing it when he was here.
So let me just come in.
There was no FOIL request and
When was the property purchased?
It says here, all persons residing in the house will have full and uninhibited access to all common areas within the house and no physical restraints of any kind.
That's not uncommon. Common area is like the entryway.
I understand that, but
What are we
you
looking at?
finally realize that we have no right to have or maintain a two-family dwelling, that such a use is allowed in this zoning district. Only pursuant to a special exception.
Why did the town change the tax? I just,
Well, I mean.
I thought you had that because you.
I didn't, I never had this.
I had no reason to believe that you didn't
Can
have
I
it.
ask
know we
the,
know it
can I
existed.
ask the owner something?
What was
When
the
you
property
purchased-
when was it purchased? When was the property?
I'm
He's looking
looking
now, I,
When the property was purchased, did you do any construction to the house to build any walls or separations between any part of the house?
No.
You didn't build anything, put up a wall or separate any rooms?
I just painted just a bit cosmetic repairs, no, not anything, like moving walls or these.
93?
Oh, 93?
No, that's when this
Oh,
Seven, 25,
That would
2019.
2019,
Okay.
July 2019.
And that was bought by, is that bought by, the LLC or
Yeah.
was that personally?
You know what, no, sorry, was done in February, not in, no, I'm getting confused.
We're supposed to be that the second kitchen wasn't closed off.
I mean, number 9, we understand that we may not advertise, sell, lease, rent, or convey the premises as other than a single-family home.
Yeah, that's Karen Harlow. That's not Mendy Worth, that's not 1 Nickel Street. I mean,
That's 1 Nicole Street.
right, it's not 1 Nickel Street LLC.
I
No,
understand
it's
that,
the
but
previous owner.
this is the previous owner. So what we're saying is that it was never a two-family. It was by special exception for a family member, but it wasn't, they could not advertise, sell, lease, rent, or convey the premises as other than a single-family home.
That's not what was done. They
Well, this is an
breached,
affidavit.
they
I'm just-
breached the affidavit. 1 Nickel Street LLC did. This affidavit, I don't know what weight this
understand that,
affidavit holds
but
weight
this
for
is,
my
but
client.
this is what we're looking at as what it was prior to your client purchasing the home.
Okay, I understand. This goes at one aspect of the analysis of whether the area and variance should be approved or not, and there's an issue of fact here. We're saying that this doesn't apply, that my client was not aware that he wasn't gonna be permitted to use it.
I want to.
Yeah, I don't.
It was bought in, February of 2019. Is that when it was purchased?
Makes sense.
Yes?
Somewhere in 2019.
Approximately, Chris. I'll get you an exact.
And this was a foreclosure,
Right,
purchased by the LLC or somebody else?
I meant the words for here.
And who's that?
Me.
Oh, it's you, okay. So you purchased it and then it was transferred to the LLC?
Right.
So now, let me just get it straight. Ultimately, when you were purchasing it, did you have any contact with the Village of Washingtonville, inquiring about the property?
So my title company did order title report with municipal searches.
Okay?
We just got the title report and they told us we cannot get municipal searches unless we have a signed smoke detector affidavit.
Okay.
Which the seller, there was no seller and the referee didn't want to sign smoke affidavit because he wasn't in the house, we didn't have
Right.
access to the house.
And that's because it's owned by a bank?
Right.
Right, a referee can't.
Right,
attest to it.
exactly.
I mean, it's not owned by the bank, it's owned by the Karen,
The county.
wasn't a bank-owned property, it was foreclosure.
So did you have any personal contact
So,
besides
my-
you can't get it? Did you ever come to the village and speak to anybody here?
Yes, so my attorney advised me to come in and do a FOIL request. She told me it's public records and I need to get it. So I
Okay?
did come in, I requested a municipal a FOIL request, and it was before John wasn't working here.
Right.
I think his name was, the name of the guy? I think he used to be for the fire department inspector.
Yeah,
You see
Bill.
Bill, yeah. And he was on, I think they told me here that he was on training, so.
He wasn't an inspector, he was a fire inspector, basically.
Okay, so they told me that he's the building inspector right now, and I need to speak to him. And he needs to get the papers from me, he needs to process the FOIL request, and it's gonna take 2 weeks. I came in to follow up. I have multiple emails to his email. I have multiple text messages, I made a lot of telephone calls, and my attorney did it as well, my title company, and I have a very good relationship with them. So they did worked very hard for me to get the municipal searches done, and no one ever answered
Did
me.
you ever get them?
So later, like just a few months before, not a few months, maybe just a month, John has a copy of the second FOIL request I did. And was right before he gave me the violation, maybe a month, 2 or 3 before. Then I also came in. You know what? It might be after he gave me the violation. I'm not even sure. But for sure after I bought the property, like months after I bought the property, I came in, I did another FOIL request. And then the lady, I think it's, I think it was Susan, she came here, you know what, I think I actually did three FOIL requests. The first one was, Susan gave it to me, she was sitting here, and she just showed me like looks like the map, I think was this paper. She just showed me that, she told me there's no CO on file, there's no nothing. She showed me one violation of the grass too high, like, she told me everything is good. Then later on I got the violation, I got another FOIL request, then John gave me he emailed me the copy of the entire file. She didn't let me, when she showed it to me the first time, she didn't let me take any pictures, and she didn't want to give me the copy. She just told me I'm allowed to see it, but not get copies. And John gave it to me. Then I figured out that there was some affidavits, but I'm not so sure if the affidavits are true or not, because I know Karen signed it, but I'm not sure she was aware. I spoke to Ben Gailey, who was attorney at the time she signed the affidavit. He told me it was the standard letter they gave for everyone after giving a violation that it's illegal to family. This is the standard letter they give to legalize it. But if the previous owner knew how to work it out, or I don't know, she just signed everything they told her to sign. But I think it really doesn't matter. I did very, very hard my due diligence.
He did thorough searches. He made every attempt possible. He just articulated.
And if the zoning board wants, I can show the emails. I can get a letter from my attorney, my title company, the big law firm, big title company. I'm positive they're gonna give it to me because they know me and I know it's true.
All right,
So I think it would be relevant to ultimately have it,
Yeah.
any and all correspondence with the village. All this discussion that you had, when was the property transferred down to the LLC?
I look it up online, but
a month ago, a year ago,
A year ago.
2 years.
not a
2
month
weeks
ago, longer than a month, that's for sure.
All right.
The violation was
Months.
issued in
Yeah,
April 2022, 1 Nickel Street LLC. So before the violation was issued in April of 2020, that really
So
got
almost
everything
a year
going.
ago, we'll say.
It was,
Okay.
it was,
Anything that you can get, any paperwork that you have, we're going to need copies of.
Oh, understood.
And, I don't know, I'm not ready to make a decision tonight. I don't know about the other board members, but I'm not, I'm not ready to make any decision.
If I just may, to wrap up my presentation, I mean, I just would like to further stress that, again, when weighing whether or not an variance should be granted, it's the benefit to the applicant against the detriment, health, and safety of the village. And I just will reiterate that if this is granted to my client, not only is it clear based on the prior, whether or not, regardless of what, like, the tax whether or not it was listed as a two-family or not, it acted as a two-family home. These area variances are not going to change the character, the health, anything about the community. In fact, this property and the location it's at would act as a perfect buffer in that spot for the other districts that it surrounds to separate the R100. All those one single-family dwellings, you have an apartment that looks like them, that buffers them. It's perfect placement for this, for what we're requesting, beyond the fact that what we're requesting is not substantial or.
Um,
So
One-
isn't,
one more-
isn't one of the reasons that they agree to allow a use to continue for the present owner but not continue and file that document in the village? Isn't that designed to get properties that are not in compliance with zoning back into zoning? And doesn't it go against the fact of permitting it to continue to remain in violation? If that was the case, they would not file these affidavits.
So, two
Right.
things. Your question is a general question. We're here for a specific application.
Well, in his situation, wasn't it filed in the village's
I don't
file?
know, I can't go, I don't understand what the village.
The affidavit says that ultimately it's not allowed to continue after this person for a two-family.
Right,
Isn't that filed in the village here for the purposes of getting the property back into compliance with
Yes.
zoning?
How is
So
my
doesn't it
client didn't have
hold on.
access to that
Hold on.
document?
Doesn't it defeat the argument that because it existed in violation before, that it supports your position to keep it moving forward in violation? Doesn't that defeat the reason that these things are designed to try to get them back into compliance with zoning?
Absolutely not. So right now, I'm asking for 5 area variances. I'm not asking the zoning board for anything beyond 5 area variances. So the zoning board is tasked with making that determination, weighing the factors available. Now, I can't get into the mind of the village in terms of why they had that affidavit from the prior owner. I can't, I don't understand, I don't know what their intention was in doing that. Mind you, if it was so important, why, that affidavit should have been right on the top of the file so that any next owner would have been able to get it immediately upon requesting it, which was not done. And so, if your point was truly valid, why wouldn't that document, if it was so important, be available to my client? He wasn't allowed to be,
Let me
it
ask
wasn't
this follow-up
available
question.
before he bought the property.
So if I go and I go up to Orange County in the file records room, okay, and I have my searcher do a search, and the government building's shut, and I try to have him search again and it's shut, and search again and it's shut, right? And I get to a point where I say, you know something, I'm gonna take the risk of just buying it without that search. Don't I bear the risk of what's filed in that location? So doesn't your client, because he got to a point of saying, I'm done asking, I don't wanna wait.
It's a foreclosure sale.
That's
He
That's
didn't
what I'm
have
saying,
time.
isn't it time sensitive, so he makes a
He
determination?
acted on the information he had. The municipal
Can I-
records had the tax assessor, had the property listed as a two-family. If
Can I
it was so
Can I
important.
ask a question?
Go ahead, of course.
Because you said that multiple times, we get that, we
It's
get
a
that.
fundamental point.
No, we got the point, trust me. How many meters are on the house?
How many meters?
Meters, electric meters. When you have two-family houses, legal two-family houses, you have meters for each dwelling.
If it's new construction, yes.
Not necessarily new
Right,
construction,
but-
no, no.
But if it's an old
no,
house,
No, in
half of
old
the
houses too, they will install another meter.
if it's
Because legally, you should,
Absolutely.
yes.
legally, if I charge the tenant, if I put the meter in the tenant's name, that's something between me and the tenant. Legally, regarding zoning
All
codes,
I'm asking you is how many meters are on the house?
one.
Should
One.
have 2 meters.
So then, when you bought the house, when you looked at the house, and you saw there was one electrical